Hello, my name's Emma Leavesley and I'm one of the family solicitors at Parfitt Cresswell. I'm going to do a talk to you about child maintenance and the proposed changes to the system. When two parents separate, one of the main concerns of the resident parent is how they will cope financially. The non-resident parent has a legal obligation to pay child maintenance to their former spouse or partner, irrelevant of whether they have actually maintained contact with their children. Child maintenance is regular monthly payments made by the non-resident parent to the parent with whom the children reside. The payments are to provide financial support to help towards the everyday living costs of the children. It is expected that these funds will be used to fund clothing, food, housing needs, utilities, etc. If you wish to seek regular child maintenance for your children, we advise that you should first try and reach an agreement directly between you and your spouse or partner. The government is promoting that parents use family-based arrangements, as these not only deal with child maintenance but also the wider costs such as school uniforms, extracurricular activities, school trips. If you are amicable with your former spouse or partner, it is hoped that you can try and agree a sum that is needed every month and then agree on how these extra costs are split. Unfortunately, some families aren't able to reach these agreements, and if you are unable to do so, then currently the agency to apply to is the Child Support Agency, also known as the CSA. The CSA was set up back in the 1990s in order to deal with child maintenance. Prior to this, the court dealt with child maintenance, but they were finding themselves increasingly overrun with the demands, so that's why the government created the CSA. The courts do sometimes stay involved with child maintenance if the non-resident parent is a high earner, i.e. they earn over £104,000 net per annum, then the resident parent can apply to the court for a top-up of child maintenance, as the CSA can only award a maximum in the region of £480 per week. When calculating child maintenance, the CSA looks at the following. They look at the net income of the non-resident parent. They look at the amount of children that maintenance is needed to be paid for. They also consider how many nights per week the children stay overnight with the non-resident parent. Whether the non-resident parent also has other children that they have to maintain outside of this family unit. There are some proposed changes to the child support system. The government's proposing to set up the child maintenance service to deal with child maintenance in situations where the claims cannot be agreed directly between the parties. Currently, the child maintenance service is dealing with child maintenance claims where there are claims involving 4 or more children. It's hoped that shortly this agency will be dealing with claims involving 2 or more children. When the parents approach the CMS, they will be given more information on options on working out child maintenance before making a claim to see if there is any opportunity that it can come to an agreement directly. If this is not possible, the child maintenance service will then become involved, and they will now look at the gross income of the non-resident parents. They're hoping that they can obtain information from HMRC in order to work out maintenance, so they're not relying on the non-resident parent to provide that information, which does slow it down. It's also proposed that will be annual reviews of child maintenance for each claim, and that both parents will get an annual statement. It's also hoped that the child maintenance service will be more forceful and they will chase payments if they're only 72 hours late in being paid. They will also hopefully be able to take payment directly from earnings, bank accounts or through court action. The CMS are obviously trying to encourage parents to come to their own arrangements, and this is furthered by the fact that they are planning to charge £20 for each application for child maintenance, unless one of the parents is a victim of domestic violence. And also, if the parents do intend to use the child maintenance service to process the payments, a fee will be incurred, which is likely to be a set percentage of the maintenance. The family team at Parfitt Cresswell regularly monitor the proposed changes for child maintenance, and if you need any assistance to reach an agreement with your former spouse or partner, then we're more than happy to help you. If you need any further information, please don't hesitate to contact us either by email at family@parfittcresswell.com or call us on 01753 271 640.